You're listening to the Valley Current.
Yeah, Zach, welcome into the Valley Current. How have you been?
Oh, thank you very much for having me. It's nice to see you again.
So I thought we'd just spend a few minutes talking about a number of things, but before we do, why don't you tell the audience a little bit about your practice, where you went to law school, where you went to work after law school? I mean, I know some of the history, but you're one of the most eminent bankruptcy professionals, in my opinion, in Silicon Valley, and I refer stuff to you all the time. And we're getting into an environment where bankruptcy seems to be becoming more and more relevant, particularly to smaller businesses that have been hurt by the triple whammy of the trifecta of pandemic plus tightening by the Fed, plus, no more free money being issued as a result of the pandemic, plus people kind of tightening their own belts, which of course affects demand in a lot of ways.
For sure, absolutely, Jack. I mean, when you talk about kind of bankruptcy and where it might be headed, the broader marketplace thinks that we may be headed for recession this coming year, and bankruptcy really tends to pick up, not surprisingly, when the economy is headed toward rougher times. We also are seeing a lot of post-COVID-19 fallout, especially actually on the business side. Kind of like you were saying, the not only among individuals, but small businesses are being really impacted on the post-COVID-19 period. Many of the clients that we work with right now, in fact, are small businesses that essentially got into too much debt during the COVID-19 period and are now needing to reorganize or eliminate that debt. And we're in a position where even with the government subsidies that applied, it just wasn't enough to compensate them for being closed for a year or more, even sometimes, especially if you're looking at restaurants, salons, retail businesses, massage therapy, any kind of business where you have high levels of contact. It can be very difficult in that regard for businesses to really cope. So we're working with a lot of both landlord clients and also on the other side, tenant clients to resolve those kinds of post-COVID liabilities.
Right. So tell us a little bit about where you went to school and how you decided to go into bankruptcy, because my recollection is bankruptcy. I took the course on secured creditors, and I mean, 50 years ago, it's a long time ago for me. But, actually, famous guy was the dean of my law school, UCLA. Dean Warren wrote the book on secured creditors and taught that course really well. People loved him. And that was a famous course. And of course, the next one after that was bankruptcy. It was like representing creditors versus representing debtors. And, my recollection is roughly that you went to Berkeley for undergrad, but then you went to the East Coast to Cornell for law school. Am I remembering this right?
I did. Yep, you remembered it perfectly. I did my undergraduate degree in legal studies, actually, at Cal. It's one of the very few colleges, actually, in the country that has an undergraduate law program, which was really interesting. And then I worked for about 2 years prior to law school in the investment community. I did foreclosure investing and basically real estate consulting and a little bit of equity and derivatives trading also. And then I applied to law school. Originally, I went to George Washington University Law School, did my first year there, and then transferred to Cornell Law School after that, and graduated there in 2008.
Yeah, I mean, Cornell, that's kind of a pretty cold place, isn't it? Upstate New York? Am I remembering it right?
Absolutely, Jack. And the tagline for Cornell and Ithaca more broadly is "Ithaca is gorgeous." While it is both gorgeous and gorgeous, it definitely snows about half the year. So I remember when I was there I think one Valentine's Day weekend, it got to negative 38 degrees with wind chill. And it definitely is nothing like Palo Alto, let's put it that way.
Well, you were born and raised in California, though, weren't you?
Yes. Yeah. I grew up here in the Bay Area, and actually close by our offices in Los Altos Hills. And I lived for my very early life in Los Gatos, and then decided that I would go to college in the Bay Area. So I lived in Berkeley, obviously, during that period. And then ultimately decided I wanted a different experience for law school. So I did 3 years on the East Coast, a year in DC and 2 years in Ithaca, of course, and then moved back here. The Bay Area is definitely my home for most of my life.
Right. So you came out of law school just as the 2008 recession, or some people would call it a depression, was unfolding, right?
For sure. So originally, while I was at Cornell, I actually worked my summer associateship at a large law firm that used to exist in San Francisco.
Yeah, Heller Ehrman, right?
Heller Ehrman, yeah. And so I was going to originally work for them post law school, but of course they imploded during the great, as you said, recession, but some would say the Great Depression. I guess you could say the second one. And at the time, I was a fresh, out of law school graduate in 2008, 2009. And so I decided that at that point, I would look into originally doing part of my practice as pro bono. I worked as lead counsel for the community groups all up and down the peninsula on actually the high-speed rail project at the time, representing community groups and kind of fighting for change with the CCHSR. And then ultimately I decided I would begin my career in solo practice, private practice, outside of a firm. And bankruptcy was obviously in extreme demand at that point. And so I selected that area of law to practice. And it was sort of opportune in one way, although not opportune in other ways, of course. But I had done my first year summer at the time with the Honorable Marilyn Morgan, who was a bankruptcy judge in San Jose Division. Mm-hmm. And so I'd already had a good bankruptcy background and kind of a heavy focus in business, which helped me as a bankruptcy lawyer. But ultimately, I've been in practice now for, I guess this will be my 14th year practice, and still going strong.
Right. I mean, you did something very non-traditional, which is lots of people come out of law school and they kind of work for big firms, as I did for a number of years, often 5 or more years, and then they kind of get the itch to do their own thing, having kind of worked for the machine, or what becomes a machine. It was a small firm when I joined, and it got big over the 5 years I was there. I'm talking about Fenwick and West, of course. And, you did it like almost right out of the gate. I guess you had some experience clerking for a bankruptcy judge, but you did something kind of very entrepreneurial in forming your own firm, right?
Yeah, very much so, Jack. I mean, I guess you could say I'm a little bit of a lifelong entrepreneur. Nova Law Group is actually my third business I've operated. And my very first business was in high school and my first year of college. I opened an academic tutoring business, and I did that until I went to Berkeley, just because locatively my clients were down here on the peninsula. So I had to end that business when I matriculated. And then secondly, I opened basically a foreclosure investment business and did foreclosure consulting pre-law school. And that was my second business, Strategic Investment Properties. And then ultimately, Nova Law Group now is my third business. But I've kind of always been self-employed for much of my life. My mother and father were self-employed for the vast majority of their lives also. So I guess we're kind of a family of entrepreneurs, you could say.
Right. So you kind of had the itch early to be on your own. And that's hard for someone doing it right out of the gate, because you have to build a client list and have to build a practice. And it takes a while to do that. I mean, it takes often years to do that. And you did it, I guess, under a name, Nova, right? Tell us more about how you selected the name Nova Law Group.
So originally, Nova Law Group was named because part of what I feel bankruptcy does, at least for my debtor side clients, and at this point in my career, as you already know, I represent debtors, creditors. I do heavy bankruptcy litigation, everything, everything bankruptcy, really. But at the time, I represented mostly debtor side clients when I opened the firm. And Nova, basically in Latin, means to start a new beginning, or a new entity, a new enterprise. And for me, I believe that bankruptcy is kind of a fresh beginning or a new beginning for my debtor side clients. Bankruptcy is literally designed to give people a fresh start, so that they can move on and really not be burdened by mistakes, honest mistakes in the past. And so I feel that it gives my clients a new beginning, and that's why the name Nova Law Group is giving clients a new beginning in that regard.
Well, it's a good name. I mean, I think it's probably distinguished you rather than just using your own name. Traditionally, law firms have not used trade names. I mean, you can, but traditionally law firms have been more like general partners like, Jones and Day and other big firms. I think that was the tradition from the time of Lincoln, and he had a partner. But these days, with the domain names that are used and with the digital marketing that occurs, oftentimes it's more beneficial to have a name that enables people to understand what you do. And, that's a little bit why we call our firm Computer Law Group, because we do a lot of computer industry litigation. And so we've been doing it for, going on 40 years, and I've been doing it for more than 40 years. But generally speaking, when you think about kind of Silicon Valley's ups and downs, we've seen a few of them. I've seen more than a few. It's sort of inevitable, isn't it, that there are going to be people, particularly business entrepreneurs, sometimes with massive failures. I mean, Theranos represents a massive failure of a business that was pretty well funded for a long period of time, and obviously with a couple of criminal convictions as well that we've talked about on the podcast series. I don't know who's handling that liquidation. I'm not sure it is an actual bankruptcy. Maybe you know whether it is or it isn't. I haven't actually seen any news about what happened to those assets. I assume there was probably secured creditors that got the benefit of all those patents that they ultimately got, and all the office chairs and other equipment and whatnot, to the extent it wasn't leased. But when you think about the ups and downs, it's sort of endemic in a culture like Silicon Valley to expect it, right?
Yeah, I mean, I think you're totally right, Jack. I mean, in terms of, taking Theranos as an example, and maybe this is a good time to bring this up. I think here in Silicon Valley, you see a lot of venture capitalists and other kind of, we'll call them multi-million-dollar, even multi-billion-dollar investors who think that general assignments for the benefit of creditors, or what we call ABCs, are the superior way to wind down businesses. And we see a lot of them, particularly among tech companies. And don't get me wrong, there are benefits to using an ABC over a bankruptcy in some situations. For example, in ABCs, you got, especially for a company like Theranos, if you have patents or other types of intellectual property that a non-bankruptcy trustee creditors feel will do a better job to market that patented technology, or maybe they they know more buyers, or they believe have a stronger incentive to obtain money for creditors. That can make sense in some circumstances. However, I really feel like my experience has been that the ABC process is sometimes overused, and the bankruptcy process is not used enough. And the major reason, and the main reason I think you run into problems, is also a situation where Theranos is an excellent example to me. Because when a company files a bankruptcy case, a petition, statements, and schedules are filed, and everything is above board to all creditors. You have to list all of your assets. The company lists their liabilities. They list in the statement of financial affairs what transfers have happened, have insiders been paid, or there are preference actions that could apply. And there's a kind of regular documenting of what happened to the company and why the company is in bankruptcy, and more broadly, why the company didn't succeed and what money there is available for creditors. And you take a situation like Theranos, where there's just rampant fraud. Creditors are very angry. They want to know where their money is and what happened to it. And you take a company like that, or some of these other tech firms, and ABC is utilized instead. And with a lot of these general assignments for the benefit of creditors, Jack, you basically just have to take the word of the trustee and the ABC that they're doing a good job in getting creditors the money that they are entitled to, because in many cases, they won't give you any disclosure, even if you request it. And that's a big problem for creditors that wonder, well, where did my money go? What happened to my investment? And they don't get any disclosures, and it's sort of like a big black box as to what occurred. And, you know, I represent creditor clients in both an ABC context and in a bankruptcy context. And one of the biggest frustrations for us as creditors counsel in ABC is when the trustee in an ABC just won't cooperate. Whereas in a bankruptcy, we have all of these tools and disclosures we could use to tell the client, look, this is what happened. This is your realistic payout. This is, you know, these are the courses of action we should take, if any, other than filing a claim to really enforce those claims.
Yeah, when you think about, I just quickly searched and it looked like Theranos got a secured loan from Fortress. Fortress does a lot of patent acquisitions. And so they essentially use their collateral. They had about 100 or over 100 patents. They were often very small incremental improvements on various ideas. A lot of them were conceptual patents. I can't claim to be an expert on all the patents that Theranos got, but they got a fair number. They were sort of like a patent machine. And Fortress is sort of a patent non-practicing entity, and they loaned them $100 million. And I guess all the creditors got paid, all the employees got laid off, and the business dissolved. So I guess it sort of took the approach probably of saying there won't be any general creditors. There's going to be one ginormous secured creditor, and ultimately that secured creditor is going to end up taking over the rest of the collateral, and no one's going to have any adverse claim. Now, of course, there were some claims that were filed. I don't know how they're being handled. I assume there must be some D&O insurance or something else that's out there to cover them. But that's just what I quickly read as you were talking, because it doesn't look like there's been a formal federal bankruptcy filing by the Theranos entity itself. It looks more like it just closed down in an orderly way.
Mm-hmm. Yeah, like you said, Jack, I mean, if you can get an entity to do that, we normally call them white knights in our industry, right, where they just come in and they say, you know, we'll give you a huge slush fund of cash and pay creditors as much as you can with it in exchange for these assets. that can be an excellent thing for creditors, especially if, like you said, what happens eventually is everyone is paid in full or a large portion of what they're owed. I think the only caveat to that, or the risk there, is that sometimes with white knight buyers, ultimately the white knight is only coming in to bail this situation out if they think they're getting a compelling internal rate of return on their investment also. And realistically, the more compelling the IRR for the white knight is, the more of, I guess you could say, the proverbial pie the white knight is getting versus, let's say, equity or debt holders of the company. And frequently, on the investor side, sometimes my concern is that when a deal in an ABC context is made with a white knight, even if liability holders are mostly paid, there can be a lot of problems in terms of equity just being thrown under the bus.
Right.
Because, that white knight may come in and deposit 100 million, but if they're buying assets that were worth 300 million and they're paying creditors in full but nothing to equity, that's giving them a disproportionate quantity of that money that a bankruptcy trustee may be able to recover for creditors and ultimately maybe equity holders after administrative fees.
Right, but I'm kind of curious. I don't want to spend the whole time we have because it's limited on Theranos, but if the shareholders, which are typically preferred shareholders, common shareholders, are upset, they don't really do they have a way to force? Usually it takes 3 creditors to force the filing of a bankruptcy, right? The equity shareholders, they can't force the filing of a bankruptcy in that context, can they?
Yeah, you're absolutely right, Jack. I mean, what happens, unfortunately, and this is part of the reason why equity can kind of, like I said, get thrown under the bus in that regard. Creditors get preference as a company is going under and winding down. And so oftentimes directors and officers of the company can make decisions, and they're actually legally required to some extent to do this, to prioritize creditor interests over equity interests. And so ultimately, you're right, whether it's a bankruptcy trustee or a trustee in an ABC, they have to prioritize creditor interests over those of equity holders. And then I think you were referencing involuntary bankruptcy proceedings earlier. You're right, it takes generally at least 3 creditors to agree to prosecute an involuntary bankruptcy proceeding against the debtor. And I will say there are circumstances in which involuntary bankruptcy is a good idea. I typically am not a huge fan of them for most clients, only because of the very significant risk and cost involved in doing those types of cases. But they can make sense in certain instances.
I guess the shareholders, if they have enough voting power, could put a new board of directors in, and the board could decide, the new board could decide. But often the way in which the voting structure is set up in a lot of these companies that have very strong founders, as Elizabeth Holmes was, is they give a disproportionate vote to the founder. And so the founder still controls the composition of the board, a little bit like Zuckerberg does for Facebook. So even if all of the preferred shareholders and all of the common shareholders and all the people that have options that want to exercise their options and turn it into voting stock, they may not have enough control to actually change the board composition. So that's not really a solution either.
Yeah, no, you're entirely right, Jack. I mean, something like, whether it's Theranos or Mark Zuckerberg at Facebook is another good example. Warren Buffett at Berkshire Hathaway is an example of the last several decades where that's been done. Warren has very significantly more voting power than his equity, Berkshire Hathaway. And they're all examples of founders or influential people having vastly more voting rights due to different classes of shares.
So let's take the more current example, which is FTX, which is complicated by the fact that it was an offshore entity, operated offshore, but apparently they filed a bankruptcy in New York, in the federal bankruptcy court in the Southern District of New York, on a voluntary basis. I know there's some reports that Sam Bankman Fried, SBF is what he goes by, kind of felt like he was forced into it, and had he had an extra 10 minutes, he might have been able to get a bailout to occur. But basically, he had a disproportionate degree of control over that company, and ultimately he decided to go with the bankruptcy approach. I imagine that's going to be a massive bankruptcy that itself is going to go on for a number of years, right?
Oh yeah, I mean, I quite frankly, Jack, that whole case I've heard is just, in fact, I think the bankruptcy trustee was quoted as saying that it was the biggest mess he had ever seen in his entire career. And I would imagine, without knowing this, but if I kind of infer what counsel was thinking in that case on the debtor's side, they probably are expecting innumerable fraudulent transfer and preference actions in that case. And that could be another reason to implement a bankruptcy filing as opposed to, let's say, a general assignment, is you get more leeway sometimes to go after transfers than in a general assignment. And that can be very relevant when you have a case of that magnitude, where there could be, hundreds or even thousands of people that you need to collect from. And bankruptcy can give you much wider powers to do that, and much more effective powers as a trustee to go after those funds. Incidentally, the same was true in the Heller-Ehrman bankruptcy about 10, 12 years ago now. Creditors ended up getting something like an 80% payout, I believe, on the general unsecured end because of the willingness of the trustees and their counsel to go after fraudulent transfers in that case and preference actions. So I would imagine you'll see that again in the Sam Bankman-Fried fiasco and similar types of cases.
Right. And when you think about it, it's probably going to be one of these cases where there's going to be a lot of learning as a result of the bankruptcy being very public about what the underbelly of the cryptocurrency exchange business is really all about. Because even though there are some trade secrets and confidential information that sort of drive the algorithms of these businesses, the truth is a lot more comes out publicly in a bankruptcy context than would ever come out in any other context, right?
Oh, for sure. I mean, and that's one of the things that I think if you're a founder or on the board of one of these companies is always a consideration, is if you opt for a general assignment approach, relatively speaking, there's likely to be much less information that is shared with not only investors, creditors, the press, ultimately, and everyone else, just due to the confidence that is allowed in that reorganization context, or liquidation context, rather. Whereas in a bankruptcy, and you could have hundreds, thousands of pages of even disclosures in some of these corporate bankruptcy filings that are obviously all public information. And someone can pull them on Pacer or whatever they want. The press can pull them on Pacer, and that leads to much, much more disclosure, which could be a good thing or a bad thing, depending on who you represent, right? So those are always considerations.
Right. And so do you follow cases like that just as a matter of general interest, or are you just too busy doing your day-to-day work? Or is that just something that's in the news you can't resist following? I see stories about it all the time and think, God, to a bankruptcy lawyer, this must be an amazing story. an offshore company operating offshore, very few employees, something like, I think 30, 35 employees running a business that was valued at $35 billion, was even far bigger than Theranos. Theranos got to $9 billion and had a lot of employees and a lot of overhead. It was kind of a relatively light overhead company for the amount of its valuation, right?
Oh yeah, crypto.
And you got the criminal aspect in it. You got the overseas jurisdictional issues in it. You got probably all sorts of arm wrestles between governments as to who's going to control what assets and where, because the Bahamas are not part of the U.S. They're an independent country. They're not governed by U.S. law. It's not like Puerto Rico, right?
Yep, you're right. Yeah, so I think the Bahamian legal system is based on the British legal system. They may even be a British territory. I'm not sure.
Right.
But they're definitely not part of the United States. You're right, and that will lead to definitely some international issues in the bankruptcy itself. And I guess to answer your first question, Jack, I think it's a mixture of both general interest and also professional interest. Why I would say I'm by no means actively involved in those cases, because many of them are pending in the Southern District of New York. But I do keep in touch with them both professionally and just as a general investor, kind of at arm's length, because they're relevant to, in general, not only recent news in our field, but just in terms of professionally, it's good to stay somewhat updated on what happens in those cases, just from a legal perspective. And because, bankruptcy law, like any other type of law, I'm sure you experience this in IP litigation also, in business litigation. Mm-hmm. It changes slowly, but it does change occasionally. And, it's in cases like these that a lot of our Chapter 11 and fraudulent transfer litigation law can really change materially, depending on what happened. And at least in our field, the Southern District of New York is generally considered one of the most highly regarded, if not the most highly regarded district in America for bankruptcy. And so even though cases out of the Southern District NY are not per se binding authority here in the Northern District of California, they are very persuasive authority for many issues. So I like to stay somewhat abreast, at least, of what those case decisions are, just for my clients.
So if there was, just to do the what if, because you have a great website that talks about the work that you do, if there was, and there are people in Silicon Valley that did have FTX accounts, and probably they may need some, depending on the amount of money that they're owed or that they claim, they may need some help. So in theory, you could represent them as a creditors counsel, or a group of them in particular as a creditors counsel. I guess you'd get admitted or come in pro hac vice into the Southern District of New York. Now, maybe there'll be some single law firm that tries to represent the entire class of customers as a whole, because there are customer claims, people that lost money that was in their accounts, right?
Sure, absolutely. And I mean, that probably will be a representation that creditors will want at some point in terms of recovering claims against the debtor in that case. Just to clarify for our purposes and those listening to the podcast, Jack, myself, I just represent clients in bankruptcy in the Northern District. So I can do cases all throughout the Northern District, San Jose, San Francisco, Oakland division. In terms of, a New York case, generally what I would do for a client that wants to consult with me around a New York case, I'm happy to have them retain me for a consultation or as a consultant in the bankruptcy matter to advise them on what their rights are. But generally, for cases that are way outside California, I recommend that the client hire local counsel in New York, at least for creditor representation in the bankruptcy to appear as counsel. And the reason is it's just much, much more cost effective.
Right.
Because a New York lawyer will be, again, they won't have to apply proc vice to appear. They'll already be aware of the New York court's local rules and local rules. They may even represent other creditors in the case. So generally, how I become involved in that case would be as a consultant, and then they would hire counsel of record in New York to appear for them if they wanted to work with me as well.
So let's use an example of kind of a typical situation these days that occurs in Silicon Valley all the time,
Sure.
which is a company gets started and the founders put in a little bit of cash and a lot of...
Stay tuned for part 2 of this episode of The Valley Current.